So do me a favor, print out the 2-page guide that goes with this lecture and join me. I'm attorney John Sofis Scheft. We're going to take a quick trip through criminal justice reform. This monstrosity, 122 pages, signed into law by Governor Baker on April 13th, 2018. But we're going to strip it down for the essential impact on you, the police officer on the street. So I'm going to begin with drugs, and I'm going to let you know that fentanyl and carfentanil, its evil twin, even more strong on the street, they're both Class A drugs. But even more important than that, any synthetic opioid defined by federal law in Schedule 1 and 2 is also automatically a Class A drug in Massachusetts right now. And that's really helpful because oftentimes the federal government is out in front when it comes to immediately classifying new and dangerous synthetic opioids, and you'll automatically be able to take advantage of that on the streets of Massachusetts. No more mandatory minimums for manufacturing, distribution, or possession with intent to distribute. Class B, Class C, and Class D. Class A, the only mandatory minimum is a subsequent offense in distribution of Class A. But don't worry, it could have been worse. They did preserve the mandatory minimums for trafficking that you know. 50 pounds minimum for marijuana, 18 grams cocaine, 18 grams of heroin, and now other opioids. But new to the trafficking statute, if you have 10 grams or over of fentanyl in any mixture, well, you're going to do a mandatory 3.5 years. And if you have any carfentanil, any amount of carfentanil, you know what? You're looking at trafficking right away. That's a mandatory 3.5 years. But in fairness, good move by the law. If it's a mixture, you have to show that the offender did know that there was carfentanil. School and park zone change, this is really different and has really neutered these laws. Well, you know the original laws were designed if you're within 300 feet of an elementary, secondary, vocational, preschool, or Head Start between 5 a.m. and midnight, any distribution offense, that used to be an automatic school zone violation. If you were within 100 feet of a public park or playground, that was automatic. But now what they did is they require that you have one of 3 aggravating factors. Otherwise, the school zone does not apply. First aggravating factor, you had a gun or dangerous weapon, or you engaged in violence or threats, or you had a participant with you who did the same thing. Or, number 2, you induced another person to commit any 94C felony within the zone. So if you're doing it with somebody else and it's felonious conduct, that's going to qualify you for school zone. And finally, if you actually distribute Class B, Class A, B, or C to somebody under 18, or you have a minor participating with you in any way in the drug dealing activity, well, that's also going to get you into school zone liability. No more being present with heroin, that law is repealed. And finally, you can't be violated on your probation anymore for lawfully prescribed medication, including medical marijuana. Well, let's go into the next topic, juveniles in schools. The public police log may no longer mention any juveniles arrest. That's going to be effective in December of this year. And how about this? They changed the age for delinquent children to 12 to 18. So 12, 13, 14, 15, 16, 17, you can be delinquent. If you're under 12, forget it. Remember, the earliest age you used to be able to be charged was 7. And by the way, you can no longer be found delinquent for the violation of any civil infraction, any ordinance or bylaw, or even a first offense misdemeanor punishable by a fine or not less than 6 months in the House of Correction. So they've really restricted who can actually be found delinquent. What about detaining the delinquent child? Well, if you end up arresting somebody 12 to 18 and court isn't in session, the OIC has to immediately notify a legal custodian. That's the term I like to use for a parent, a guardian, a caretaker who lives with the child, or the child may be in the custody of an agency like DCF. Naturally, if it's a DCF kid, the OIC is going to call them directly. You can only detain a child post-arrest. In other words, you're not going to release them with that written form to a legal custodian. You may only hold that child if they're 14 to 18, the arresting officer requests it in writing, or the arrest warrant directs it. But very, very important, even if you hold that child, you do not release them because the warrant directs it or the arresting officer requests in writing, 14 to 18-year-old, you still always have to notify the bail commissioner, and they have to give that child a bail hearing. Remember, the child always has an opportunity for bail. A couple of other things. There's now a parent-child privilege. Parents may not testify against their children, and children may not testify against their parents, provided the victim in the case is not a family member and does not reside in the same household. Believe it or not, that didn't exist under prior law, but now it's one of the protections for the parent-child relationship. And parent is broadly defined any biological, adoptive parent, guardian, and the like. Hey, there's a lot on school resource officers. You already know that there has to be a memorandum of understanding between the school superintendent and the chief of police about how SROs are going to function. Well, that's still the case, but now the law is very clear that really the trend is that school resource officers will not be involved in typical school discipline, disruptive conduct. They are told not to criminalize nonviolent disruptive conduct as much as possible. And at the same time, school resource officers are not supposed to view themselves as counselors and psychologists, really somebody in the middle, school safety, part of the life of the community, not a counselor, not a full-fledged, enforcer in the schools. You're supposed to tread that middle ground. At the same time, there's a little bit of a misconception out there. Now, you may not be adjudicated delinquent if you are a juvenile for disorderly conduct, disturbing the peace, and interrupting an assembly if it occurs on school grounds or at a school-related event. But you may still be arrested for it. Now, clearly, the trend in the law, the preferred response is not to arrest students under 18 in school for nonviolent disruptive conduct. But again, if you are an officer and you run into the situation where you think, look, arrest is absolutely essential, you certainly may make an arrest. Adjudicated delinquent simply means that the juvenile court cannot, quote, convict them and punish them, but that does not affect your arrest authority in the field. And courts may still divert kids that are charged with this or even dismiss it with court cots. There are other informal sanctions that are still available. Now, of course, this only applies to students at school events or on school property. If they're elsewhere in the community and disorderly and disturbing is appropriate, you can arrest. If they are not under 18, well, you can arrest and they can be convicted in adult court for these crimes wherever it occurs. Well, what about motor vehicle offenses? I think a really important change in the law is under the earlier version of the OUI statute, it was only OUI if you were, quote, under the influence of the vapors of glue. And you may remember a case called Commonwealth versus Sousa in Malden talking about how restrictive this was for a normal OUI prosecution. Well, good news, that's gone. And now, if you find somebody in a vehicle, in a boat, on a snowmobile, in a wrecked vehicle, any OUI offense, including, by the way, carrying a firearm under the influence, any of these offenses always include any inhalant, which is any substance that you would inhale for the purpose of exhilaration or dulled senses. It's the same definition you're very familiar with in Chapter 270, Section 18. Police protection. Hey, it's about time. Assault and battery on a police officer. If the offender now causes serious bodily injury, which is defined as permanent disfigurement, protracted loss or impairment of a bodily function, limb or organ, or substantial risk of death, it's the same standard that's currently used for felony assault and battery under 265.13a. Well, if you do that to a police officer, that's a mandatory year in jail. Mandatory year in jail. One of the glitches, I hope it will be worked out in the future, is as it is currently written, if it's assault and battery on a police officer causing serious bodily injury, it can only be brought in the superior court. Well, justice system integrity. The witness intimidation statute 268.13b now includes some additional officials in the court system, interpreters, victim witness advocates. But I think most important from your perspective is whoever you intimidate now, they're not only protected, whether they're a victim or a police officer or anybody else involved in the system, but all family members are protected. All family members are protected. And another thing that's great is there was a technical problem because there were certain offenses under 268.13b that could not be brought in the district court. Well, you know what? Now all of your offenses under 13b district court jurisdiction, including the one that you use quite a bit, misleading a police officer. How about 268.34a? You know that I can't lie to you about my name or my social security number post-arrest. But the statute now covers any information post-arrest that is being asked for the purpose of identifying me. If I lie about my mother's maiden name, if I lie about my home address, my mailing address, anything that you're asking to identify me, now I come under the orbit of 268.34a. Convicted felons, whether they're on probation or they're incarcerated, have to submit a DNA sample. Excellent. If they don't, it's a crime. And I love this. They can't even be released from incarceration until they provide that DNA sample. By the way, good move. Probation officers can now collect the DNA sample. Makes it administratively so streamlined. You can seal or expunge records now more easily. The standard for sealing a record is a misdemeanor not less than 3 years after the fact, and for felonies not less than 7 years. And I think we'd all agree this is only fair. If I do have a sealed record, it cannot be used to screen me for employment, for housing, or for a professional license. There's also a legal procedure for expunging your record. Expunging means to totally erase, to permanently destroy. And that is done in a variety of situations, most importantly where a conviction is obviously erroneous or obviously obtained by fraud. And last thing I'll mention here, gone is the bail bonds industry. Nobody can make money anymore for giving surety to somebody on bail. Well, here's another important category, theft and economic crime. You know it for both larceny, for receiving stolen property, for credit card offenses where you actually get something. Now the threshold for a felony has gone from over $250 to over $1,200. But I love what the legislature did at the urging of police officers. You still have your right of arrest for larceny, for receiving stolen property, if the value of the property taken is over $250. It'll be a misdemeanor, but you'll have your right of arrest on probable cause like you've always had. That will continue. In the area of shoplifting, you know how with shoplifting, if you steal items, retail items with a value of less than $100, shoplifting is the only available charge and you can't go to jail? Well, now that threshold has gone up to $250. So If I steal retail goods with a value of less than $250, that's still only shoplifting, and I can't go to jail until the amount of the retail goods is $250 and over. But remember, if it's $250 and over, you could also charge the applicable larceny, whether it's under $1,200 or over $1,200. So that option is still there for you. There's a new identity fraud violation. I think this will be very helpful to you. It covers any tool or instrument that is designed to accessing a person's number or code for really everything: financial services, savings, checking, brokerage account, a credit or debit card, ATM, computer password, or an electronic signature or biometric data. Excuse the phone ringing. I'm still talking about this important offense, with the intent to commit a larceny, to commit a theft. Now, this is going to apply to things like somebody who uses a skimmer at an ATM machine, but I think any computer or software will work on this offense. And let me tell you about a quick case here called Commonwealth versus Labadie, Labadie. This was before the appeals court in 2012 and actually involved the charge of possession of tools for counterfeiting. So the defendant had a computer and a printer and was basically going to come up with some counterfeit currency and print it out. He was convicted, and his argument was, well, wait a minute, a computer and a printer, those are ordinary items. And the court said, for the purpose of this statute, they are tools that you have configured to commit this offense. Well, if I use my computer or my printer to try and get access to your financial account, your checking account, to try and figure out your computer password or other biometric indicators like your signature, your retinal data and the like, that's where we're going technologically. Well, you know what? I think it's going to be covered under this statute, no question about it. Remember, anything under the identity fraud statute, yes, it's a misdemeanor, but it's always arrestable on probable cause. Final couple of points. There's now an ambitious statewide undertaking to process appropriately these sexual assault kits. So the hospital will now have 24 hours to turn over that kit to inform the police about the existence of a sexual assault kit. The police have to obtain it within 3 business days. They have to submit it to the lab within 7 business days, and the lab will have 30 days to process those results, and it's all going to be put into a new tracking system from the Executive Office of Public Safety. But there is an exception in the event that it's what we call a non-investigatory kit, where the victim doesn't want to go forward. The police department will not have to adhere to this schedule for analysis, but they'll have to keep the kit in the evidence room for the entire statute of limitations period in case that victim changes their mind and now this forensic evidence should be processed. There is now a statutory offense for solicitation of a felony, and it's defined exactly the way it's always been under common law if you solicit somebody to commit a felony. But good news is you now see it in the statute. It's 274 Section 8. And the last thing I'm going to mention in our whirlwind tour of the new crime bill is the Good Samaritan law for alcohol incapacitation. Now, if you're under 21 and you seek help, you call 911 because you're incapacitated, or you call 911 because somebody you know under 21 is incapacitated, you're immune from being prosecuted as a social host, as a minor in possession, or as somebody who procured or attempted to procure alcohol for somebody under 21. Now, pay attention to this language because you have to be under 21 to obtain this immunity. If I'm hosting a party, obviously I'm over 21, then I don't get immunity from the social host law. It's only if my 17-year-old son is hosting a party and calls 911 because one of the guests is really incapacitated and they want to get him medical attention. Well, my son under this scenario would be immune from being a social host. He'd be immune from minor in possession. The person he called about would be immune from minor in possession. All right. I hope this has been helpful for you. Thank you.